Mrs. Wagenthal, seconded by Mr. Albrecht, moves that Bill C-225, an act to amend the criminal code injuring or causing the death of a preborn child while committing an offense, be now read, a second time and referred to the Standing Committee on Justice and Human Rights. Debate. The Honourable Member for Yorkton Melville.
Mr. Speaker, I'm honoured to stand today in support of my private member's Bill C-225, the Protection of Pregnant Women and Their Preborn Children Act, which I will refer to as Cassie and Molly's Law. I was motivated to bring forward this bill after learning about the very tragic story of Cassie and Molly Cake from Windsor, Ontario. Cassie was 7 months pregnant with Molly when she was brutally attacked and killed in her home in December 2014. Molly's father, Jeff Durham, has been working tirelessly to bring some good out of this horrific tragedy. I'd like to quote now from a statement Jeff Durham made on the day I introduced this bill in the House. He said, "Without a shadow of a doubt in my mind, neither Cassie nor any pregnant victims of homicide or violence would want their choice, their babies, to go ignored, just because they're not here to say this law is needed. For anyone with a conscience and the power to do something about it, I say for them that this bill is needed." Mr. Speaker, I'd like to explain now exactly what Bill C-225 does, and just as importantly, what it does not. This bill creates new offences for injuring or causing the death of a pregnant woman's preborn child while committing or attempting to commit a criminal offence against the woman, for example, while assaulting or killing a pregnant woman, with the knowledge that she is pregnant. These offences are not standalone offences. They would only apply when a person is, and I stress, committing or attempting to commit a criminal offence against a pregnant woman, and in addition, only when the offender has the knowledge that she is pregnant. The new offences are called causing the death of a preborn child while committing an offence and injuring a preborn child while committing an offence. With this law in effect, 2 charges can be laid in crimes involving attacks on pregnant women that result in harm or death to their preborn children. One charge would be in relation to the criminal offence against the woman, and the second charge would be in relation to one of the new offences created by the bill, that is, either causing the death of the preborn child or causing injury to her preborn child. This bill also adds pregnancy to the list of aggravating factors for sentencing purposes. Although judges can already treat pregnancy as an aggravating factor today, codifying it in the criminal law is a way to more clearly and strongly denounce violence against pregnant women. We know from researching the case law that it is often unclear to what extent a woman's pregnancy is considered in sentencing. This bill sends a strong message to the courts that pregnancy must now be considered in the sentencing hearing. Mr. Speaker, pregnancy should be a joyful and exciting time, the building of a family and a new generation. Unfortunately, the tragedy of Cassie and Molly, along with too many other Canadian women that were targeted and harmed because of their choice to carry their child to term, reminds us that the safety of women remains threatened. According to the Canadian perinatal surveillance system, women abused during pregnancy were 4 times as likely as other abused women to report having experienced very serious violence, including being beaten, choked, threatened with a gun or a knife, or sexually assaulted. Cassie and Molly's Law will be a strong deterrent to committing violence against pregnant women because of the severe penalties it carries for intentionally causing the death of a preborn child. In existing criminal law, if a pregnant woman is assaulted, not killed, and her child dies, the offender is charged only with assault on the woman, which carries a maximum penalty of 14 years for aggravated assault. Under Cassie and Molly's Law, the offender would be charged not only with the assault on the woman, but also with the new offence for causing the death of her fetus. If her attacker's intention was to kill her preborn child, then that person will be liable to imprisonment for life with a minimum punishment of 10 years. So this is a far stiffer penalty than the offender would get under the simple charge of assaulting the woman. Not only that, a judge has discretion on whether or not to impose consecutive or concurrent sentences. So in cases where this new law is applied, judges may very well require the offender to serve the sentence for each offence consecutively. In the most tragic case where both the woman and her preborn child die, as was the case with Cassie and Molly, as was the case with Olivia and Lane Jr., when the assailant confessed his intention was to kill the child, shooting Olivia 3 times in the abdomen before shooting her twice in the head. The judge may impose 2 life sentences, and at the judge's discretion, these could be served consecutively. Mr. Speaker, I want to be very clear about the intent of this bill so that there's no misunderstanding of what it is attempting to do. Cassie and Molly's law is about protecting pregnant women and their preborn children from the actions of third parties who want to do them harm. It protects a pregnant woman's choice to bring her child safely to term. I've been assured by legal experts that this bill cannot in any way be used to impact a woman's choice to terminate her pregnancy. Abortion is, by definition, excluded from the bill because of the clear wording that makes causing injury or death to the preborn child an offence only if the person does so, and I'm quoting here from the exact wording of the bill, while committing or attempting to commit an offence under this Act against a female person that the person knows is pregnant, end quote. I want to reinforce that these new offences are not stand-alone offences. The new offences in Cassie and Molly's law address only the situations where a third party harms or kills a woman's preborn child while committing or attempting to commit a criminal offence against the woman, action which she is clearly not consenting to. This legislation honors and protects a woman's right to choose to give birth to her baby free from harm committed by others against her will. Mr. Speaker, Cassie had chosen to have Molly and was so looking forward to mothering her. As Molly's father, Jeff, stated, before they were killed, Cassie was the happiest anyone had ever seen her. She was happy to have chosen to be having our baby girl. She beamed with excitement and anticipation that was impossible for anyone who knew her not to see, end quote. As the title of Bill C-225 makes clear, this law would protect pregnant women and their preborn children. With respect to preborn children, our health care system already offers them substantial protection. So why not our criminal justice system? In the area of fetal medicine, surgeons are able to perform delicate surgeries while babies are still in the womb, like treatments for fetuses with spina bifida and life-saving heart interventions. In the case of a pregnant woman who is rushed to the hospital after sustaining serious injuries in a car accident, physicians will do everything in their power to save the lives of both the woman and her unborn child. Even if the mother tragically dies, the doctors will not give up hope on saving her baby's life. No one questions these policy decisions because they are common sense. It makes perfect sense to save the baby in utero who is struggling to survive after its mother was harmed or killed in a car accident. But in the house across the street, there's another pregnant woman, and she is being beaten and kicked in the abdomen and loses her baby as a result. What doesn't make sense is that this woman's child doesn't matter in the eyes of our justice system, just like Molly, just like Lane Jr. Our justice system says it doesn't matter that their lives were brutally taken when their mothers were brutally attacked. Why should women, when they are at their most vulnerable, not have the backing of our criminal law to help them to protect what is most precious to them? It's simply wrong and completely incoherent when compared to the effort and resources our healthcare system puts into improving and saving prenatal life. No one makes the argument that in order to protect abortion, we should not be performing life-saving surgeries on babies in utero. We allow both types of surgeries to take place in our hospitals based on a woman's choice. Our criminal justice system should do the same. If we can allow abortion to coexist with life-saving fetal surgeries in our healthcare system, then we can allow legal abortions to coexist with a law in our justice system that makes it a crime for a third party to harm or kill a woman's preborn child against her will. To do otherwise not only lacks coherence, it lacks compassion. I turn now to concerns expressed in the past by the medical profession. I understand that several physicians' groups feared that a similar bill, C-484, which was debated in Parliament in 2008, could criminalize doctors for performing abortions. I want to assure Canadian physicians that I have paid close attention to those concerns in drafting Cassie and Molly's law. Provisions in the earlier bill, C-484, explicitly excluded consensual abortion under a for greater certainty clause. However, that provision was causing concern amongst some physicians who thought it would criminalize them for performing abortions. It was not a necessary provision and was only included for greater certainty. Given it did not have its intended effect, that is, to make it clearer that abortion would not be criminalized, and on the advice of my legal drafter, I decided not to include that provision in my bill. I've been assured by legal experts that this law cannot be used to criminalize doctors for performing abortions. I am confident that this new approach will assuage any concerns Canadian physicians had with the earlier bill. The reason this bill does not interfere with the duties of physicians is that a person could only be charged with one of the new offenses created in that bill if that person commits or attempts to commit a criminal offense against the pregnant woman. A doctor performing an abortion on a consenting woman is not committing any criminal offense against the woman, since abortion is not regulated by criminal law in Canada and hasn't been since 1988. Therefore, these new offenses would not apply. They are not standalone offenses, meaning they can only apply while committing or attempting to commit a criminal offense against the woman. I've also been assured by legal experts that Cassie and Molly's law cannot be used to prosecute a pregnant woman in Canada for any harm she may cause to her own preborn child. This is because, by definition, the new offenses only apply when a person knowingly commits a criminal act against a pregnant woman and thereby harms or kills her preborn child. Simply put, this bill is strictly aimed at third parties who knowingly commit a crime against a pregnant woman and in the process harm or kill a preborn child. And importantly, C-225 could never act as a precedent for the courts to criminalize the behavior of pregnant women because Canada's criminal justice system does not allow courts to create criminal offences. That is the exclusive jurisdiction of Parliament. So there's absolutely no way that Cassie and Molly's law could now or ever be used to criminalize any act or omission by a pregnant woman with respect to her own pregnancy. Another point that must be stated clearly to negate any confusion about this bill relates to the definition of human being in the criminal code. This bill does not change the legal definition of human being or create fetal personhood, as some critics have tried to claim. Because the criminal code definition of human being precludes preborn children, the existing criminal offenses against human beings, murder, manslaughter, assault, do not apply when the preborn child is harmed or killed during the attacks against the pregnant women. Instead, this bill creates brand new offenses to cover the very narrow circumstances whereby a preborn child is harmed or killed during the commission of an offense against the mother, in spite of the fact that these children are not considered human beings in our criminal law. The criminal law can be used to protect entities other than what is covered under the criminal code's definition of a human being. For example, the criminal code in section 238 already protects a child during the act of birth by making it an offense to cause that child's death in such a way that if the child were a human being, it would be murder, even though that child during the act of birth is not a human being under the criminal code definition. And we have criminal laws to protect animals from cruelty and against unlawful killing or injury of animals. There are also criminal law protection against the destruction of private property. Mr. Speaker, families are the foundation of our country. The criminal code is missing a crucial component to protect Canadian women and their families. The increased penalties under Cassie and Molly's law create a legal mechanism that will enhance the safety of Canadian women and recognize the safety of their families. This approach is specific and robust. It is a common sense approach designed to fill a gap in the criminal code that renders women and their preborn children vulnerable. I truly believe that all my colleagues want to do what they believe is compassionate and just. We should not turn a blind eye to the brutal violation of Cassie's choice to continue her pregnancy. We should not turn a blind eye to Molly's death. We are parliamentarians and have a long overdue opportunity to bring something good out of a horrific tragedy that is actually only one of many, many. It is my sincere hope that we can put partisanship aside. I am asking for all of my colleagues to listen to their conscience and to listen to everyday Canadians who instinctively know that it's simply wrong to violate a woman's pregnancy and cause the death of her yet-to-be-born child against her will. As legislators, we must hold up our responsibility to protect the innocent with sound reasoning combined with compassionate and caring instincts. Let us protect pregnant women. Let's work together to increase the chances that a pregnant woman will be able to continue her pregnancy free from violence. Let's protect the child she longs to bring into her family. One of the tools we as federal parliamentarians have at our disposal to offer this much-needed protection is the criminal law. It's the 21st century, and the time is right. Protect pregnant women and their preborn children. Vote for the passage of Cassie and Molly's law. Thank you, Mr. Speaker.